Welcome to the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. We're talking about asset protection this week here on the Professional Edge. And what does that actually mean? Well, we talked about putting the liability fence around the rental properties. There in session number 1, session number 2, we talked about asset protecting for the surviving spouse. So let's continue down along that vein and say, okay, what about asset protection for our kids? Well, you say, hey, you know what? When my kids inherit the money, they're going to spend it anyway. Unfortunately, let's not go that route. So let's think about this for a second. If you have 2 children, well, we got a 50% chance that their marriage is going to end in divorce. That's the numbers. 50% plus of all marriages now are going to end in divorce. And do you want your child's share of their inheritance going to that ex-son-in-law or daughter-in-law? There is a big no. So let's protect that for them. Their marriage may survive 30, 50 years. We don't know. But let's put in place a asset protection trust. So if the marriage does go south, or if their spouse is in a high litigation practice, or in a profession, let's say they're a doctor, a surgeon, there's a high probability they will get sued sometime during their career. So let's not expose those assets to the claims of that creditor either. So how do we do this? Well, within your estate plan, we draft what is known as a testamentary trust, which says when the kids receive their inheritance, we're going to place this in trust for them. Now, it's the only time under law that they can be the trustee, they can be the beneficiary, and we have 100% creditor protection. So with that, we can say give something outright to them as part of your estate plan, call it $50,000, $100,000, and they can go and squander that, do whatever they want. But if you have a spendthrift child, what I would strongly recommend is placing the final balance of that. We're going to give them $50,000 outright, and then we're going to put the balance in trust for them. So that way they can't squander it. They may have some alcohol or drug addiction. They may be addicted to gambling. Who knows what's going on? So let's just place this in trust for their benefit and allow them to be the trustee. We can always assign a trust protector to that trust. So therefore, the guise of the trust and the intention of that trust is not going to be violated, and let them distribute those monies and squander them. So we're going to have this in place, and we're going to keep these assets there. And let's say your child is 30 years old right now. We're going to keep this in trust until, let's say, the age of 50. We're going to give them distributions along the way. We can say we'll match what their annual income is. We can say for the trust to distribute all income unless they're going to harm themselves. Let's say they're on a bender, and any more additional funds will just be used to buy more alcohol. So the trustee would say, trust protector would say, no, we're going to hold on to these proceeds right here and put them back in the corpus of the trust. So that's one consideration, is that we are going to place it in trust for that 30-year-old child. We're going to distribute 1/3 5 years after your passing, another 1/3 5 years later, and then the final balance 10 years later. And you say, why would you do that? Well, we are protecting them from taking all that money and going out and buying a camper, buying a crazy vacation, buying a sports car, buying a bigger home. And before you know it, they're in trouble because now all the assets are spent and they don't have the cash flow to support all these new assets that they purchase. You got to insure the trailer. You got to insure the new home. You have higher real estate taxes on that more expensive home. So we keep them out of jeopardy from inheriting these assets. And you think about it, when was the last time that you inherited a couple $100,000 income tax free? Well, that's the thing. You become sudden rich and you think this is a lot of money. It is, but it's not. So we protect them from squandering these assets that you took a lifetime to accumulate. We're going to place them in trust. So A, their creditors cannot receive them, and the largest potential creditor is your ex-spouse. So we place this in there. We allow them to use it, go to Disney World, fund kids' educations, or being your grandkids' education, things such as that. But it's not going to be subject to the claims of our creditors. So if this is the level of planning you have not implemented in your estate plan, do give our office a call at 877-654-9798. That number again, 877-654-9798. With the advent of Zoom and Teams meetings, we can meet with you in the comfort of your own living room. And we can have this conversation to see what exactly you're trying to accomplish. Having an I love you will remainder to the kids in equal shares is not going to protect them with any asset protection whatsoever. So if you're okay, and if your kids are married, whether their marriage is strong or there's some indications, that things are on the rocks, well, then take it upon yourself to say, okay, let's plan this estate to where when my daughter or son receives their inheritance, it's going to go in trust for them. But if their marriage should not work out, then that ex-spouse is not going to have a claim against these assets that they inherited. Simple as that. It's not that you're denying them, it's that you're protecting them. And it's one of the only times under law when you can have asset protection and be in charge of your assets. Pretty significant, and a lot of people miss this opportunity on putting this plan in place. I've had some very astute clients which have said, hey, you know what? This type of planning makes a lot of financial and asset protection sense. Let's go ahead and update these things. So again, if your document is, I love my spouse, outright to my spouse, in session number 2, we said why that would not be good, because you risk the chance of disinheriting your children 100%. So if you don't want to disinherit your kids, listen to session number 2. But on this session, we have those proceeds going down to the kids, and we're not going to give it to them outright to be subject to the claims of our creditors. We're going to place this in a testamentary trust, protect them from themselves. That's number 1, and protect them from their creditors. Number 2, and allow them access. So if they lose their job, we're not going to keep these assets away from them and make them have their house foreclosed on. We're going to be able to access these trust assets, be able to pay that mortgage, supplement the income until they get back on their feet and get a job and get going towards the right direction. So it's like a big safety net, a big bank that sits here and protects these assets that you worked your entire lifetime for. So that is a very technical way of saying things. We're going to give the surviving spouse a trust share, and then when the surviving spouse passes away, we're going to take that trust share and give the kids a trust share. So if that is not the type of planning you have, and it is of significance that you want to guarantee you're not going to disinherit your kids, and when your kids receive these monies, they are also not going to be subject to the claims of their creditors. Pretty thoughtful planning. Do give our office a call at 877-654-9798. That number again, 877-654-9798. And we can start that conversation to say, hey, you know what? There's a better plan to asset protect your estate and make sure that your surviving spouse has asset protection and your kids have asset protection. And this is not your legalforms.com or legalzoom.com. They don't go through this level of depth on protecting your assets. Yeah, you can get a generic set of documents and you're going to get what you pay for. So if you have an estate north of $500,000, 2 kids, and you want to protect $250,000 from the claims of creditors of your of your surviving spouse and your children from not being disinherited, then this type of planning is of significance to you. And again, that number to call is 877-654-9798. That number again, 877-654-9798. So Turning to what else we can do for the kids on a trust, we can say, okay, we're going to make it an incentive trust. So they're not going to be trust fund kids to where they get this stipend each and every month and they basically quit their job and become worthless. What we can do is make it an incentive trust to where depending on their take-home pay or whatever compensation that they receive, there's going to be a 50% match or a 100% match, however that goes. And therefore, it's going to incentivize them to make more, because the more they make of their own efforts, then the trust gets to distribute more money to them. That's one thing that has worked very well. But we also have, if they lose their job, unfortunate circumstances that they didn't cause, then the trust is sitting here ready to avail them so they can access those principal proceeds and use those to pay the mortgage payment, pay for groceries until they do find a replacement position. So again, you're protecting the kids from basically squandering the money within 90 days. And yes, on average, an inheritance is spent within 90 days date of your passing. Think about that. You've taken 30 or 40 years to accumulate all these assets, and your kids spend it within 93 days. And you're probably looking at yourself and saying, well, one of my kids is going to probably spend it in 93 days, but the other one's going to be okay. Well, protect them from that spending habit and give them a little bit to spend out front. The balance goes in trust. And now they're going to receive a distribution for the next 20 years. Think about that. Think about how you would like a distribution from a trust for 20 years. That would be a significant change in your life, your lifestyle, that you could say, you know what, whatever comes from the trust is from mom and dad, and I'm going to take this, I'm going to go on a vacation and just remember them and all the great times and create some memories for my children of that. And being the grandparent, you're funding it for the grandkids. Think about that for a second. They'll think of all these vacations and your kids will be like, well, you know what? Your grandparents were pretty smart. They put this money in trust and they knew or they desired that we use the income from this trust for family vacations. And they were astute enough to put this planning in place and fund our family vacations. So the person you need to think of and thank is your grandparents. Think about that one for a second. That legacy of 20 years of family vacations because you had the foresight to place in trust for them this testamentary trust. That's pretty profound. So to start that conversation, give our office a call at 877-654-9798. That number again, 877-654-9798. My name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on The Professional Edge. We have more coming up. Stay tuned.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.